Closed. Not seeing any. I will move then to Part 7, National Vending Committee, Clause 21. Deputy Chief, floor is yours.
Chair, this Clause 21 deals with the establishment of the National Vending Committee. So the clause speaks to the establishment, but then also speaks to the citation of the 6th schedule to deal with the members of the committee and other procedures relating to the committee. So if we go to the 6th schedule, this is on page 64 for those who are going by pages.
Right.
As you can see, the constitution of the committee is set out. You will note from the note that was submitted to the committee that there was an insertion of a representative of the Ministry responsible for tourism. So in the draft that would have been submitted with the amendments arising out of the last meeting, that insertion would have been made. But as you can see, all the members are set out. Minister can appoint a chairperson. It deals with tenure, resignation, publication, procedure for meetings, and remuneration. So if there are any submissions to be made in relation to Clause 21, opening the floor. Thank you.
Colleagues, are there any interventions sought under Clause 21? If not, we'll move to Clause 22, which gives you an opportunity to have...
Mr. Chairman?
Yes, Dr.
Again, I'm conscious that you may not have seen the raised hand.
No, I apologize. Please proceed. Floor is yours.
Noted. Thank you, sir. I am reviewing the 6th schedule, the composition of the committee, and whereas I quite agree with the addition of the Ministry of Tourism, I note, Chair, that there is also a trade association that is missing from this list that, from my recollection, has in excess of 100 of its members that are vendors. And so as we have the Association of Bayside Vendors and Barbing, I would wish to make a submission, sir, that this association, known as the Small Business Association of Barbados, be considered by the committee as well for inclusion on this National Vending Committee.
Noted. Any views on that, colleagues? Mr. Combach, you want the floor?
Chair, yeah, I think that the SBA plays a very important role in the ecosystem, and I have no difficulty with including them as a member of the committee.
Fine, thank you. Minister Goodenejo.
Thank you, Chair. Not on that point specifically, but dealing with the 6th schedule. I just wanted to understand at G and H, you have the manager of markets, and then you have the senior manager of markets. And I recognize at the last count there were 16 persons on the committee, plus if we add the SBA, there's 17. But I would like to understand why we need to have the manager of markets and the senior manager of markets at G and H. Thanks, sir.
The challenge is, Minister, that the manager of markets, if I recall correctly, is a creature under the office rather, is a creature under the Ministry of Agriculture, whereas the senior manager of markets office is created under the Ministry of Fisheries. And that creates that challenge for us.
Understood, Chair. But perhaps then, Chair, just out of clarity, I think we should probably make the point here is manager markets, if it's fisheries or senior manager markets, and the ministry associated with that post, so that we don't get confused, so that another person will do the same thing I'm doing and ask the question.
Right.
Chair,
Yes.
just in relation to the clause 2, which speaks to the definitions, the manager of markets is defined and the senior manager of markets is defined.
Oh, it is done earlier in the act. That's your point? That's your
Yes, Chair, so that it is made clear what the portfolio of the manager of markets would be and the portfolio of the senior manager of markets. And the senior manager of markets is especially included to deal with the fish markets. Thank you.
You said that has to be found at clause 2 of the bill?
Yes, Chair.
Right. In the definition section.
Mr. Chair, could you be gracious and accommodating enough to allow me to go back to part 5, clause 18, subsection E3, that speaks to not E3, E1. I just hope that we have some clarity on this term, insulting gestures. I hope that we can at least break that down so that we have a clear understanding of what it is that we want to address by insulting gestures. Because what is accepted by one set of people as insulting gestures might be just a normal way. I will tell you why. I've had the experience of a young lady who was dismissed from a government institution once because after having conversation with management, the lady walked away swaying her hips, and the management interpret that to be indifference. Figure that she showed no respect for management, and because the nature of the employment, the physique, the physique was extremely rhythmic, and the management was offended and decided that she would dismiss her from the job. So if this is a bit wide, and it gives some comfort to people who think in that specific way.
Chair,
So I hope you
just to indicate that in the Public Order Act, it speaks to abusive, insulting words or behavior. Behavior would be larger than gestures. So there are different wording that would be used throughout legislation, and they're normal within the statute book. Thank you.
most legislation, when we have things that sound a bit abstract, the legislation normally states, for the purpose of this act, such a term or such a word is described as such. In many areas of modern legislation, when you have something that is so expansive, there's a clear indication in the act that you give it a clear definition to see how it relates. Or only if there's established judicial precedent that you can rely on the precedent and apply it to the actual legislation itself. I don't know, just suggesting that. You're the expert, but I'm suggesting that we be very clear on what this attempt to capture body language that is good and body language that is bad what it is that you intend to have. In modern times, we're seeing young people doing so, and sometimes when they say so, we're in agreement. Sometimes when they do it in this way, right? You can interpret that to suit you. And if an employee talking to somebody, boy, do so, to come slow. It is one thing to come and do so, push it forward, so it's a different thing. So I just said these things, it's different if a man talking to a manager, he takes off his spats and he turn around. I believe that might be interpreted as some level of obscene or form of indecency or something like that. But these new terms that we see being introduced into law, even people that understand the English language well, and I certainly don't purport to be one, but we know that those terms are a bit too extensive. It's just a small point that I just saw, and I just figured that we can think about it and at least be very, very clear, or at least in some area where we're clearly defining language according to the Act itself. We have a provision in there that says this is what it really means, so that ordinary people can understand it as well as lawyers as well.
Ms. Bell, do you feel particularly strongly on the question of gestures? I know
Chair,
you
can change it to behavior, but for instance, in the Public Order Act, it's actually an offense. In this act, it's basically subject to an administrative penalty. So the thing is that, to me, the gesture is lower than behavior. You can put in behavior, and that will...
Insulting behavior?
Yes, because you have...
It says insulting in the Public Order Act.
So in the Public Order Act, it speaks about threatening, abusive, or insulting words or behavior.
Then maybe we should emulate the language of the Public Order Act. Now, if I could go back then, colleagues, to the the sixth schedule, to directly treat to Dr. Holder's point, I don't think there's any objection to the Small Business Association being named. I do, however, also feel, Ms. Bell, that even though we have defined this matter of manager markets and senior manager markets in the legislation, it may be useful for the avoidance of doubt to find a form of words, even if it only takes us back to the original
Chair,
clause.
that would be cumbersome and against...
I know.
Yeah, and I think that when there are conventions on interpretation of legislation, I mean, you should observe them. That is why you put the definitions in Clause 2, to inform how those expressions are to be interpreted. So I don't think that it would be wise.
It does not look tidy. I agree with you. But I just recognize that this keeps on coming back up repeatedly.
Chair, then it requires persons to read. That's what it requires. I'm sorry, but you do have to read.
Miss Bell, I'm sure that you genuinely feel that way, but I equally am feeling that it might be necessary for us to try to make life a little bit easier for those who, as you put it, have not read fully. Kindly reflect on it, if you could come up with a form of words that might be able to accommodate G and H without it being overly cumbersome. Colleagues, are there any other concerns we have about the sixth schedule? Okay, then we can move to clause 22, which is the elaboration upon the functions of the committee. Sorry, Senator Wiggins. Before we go there, I think I see Senator Wiggins' hand online.
Yes, sir. Thank you.
Senator Wiggins, you're muted.
From probably by the host, not by me.
Indeed, I would not have wanted the host to have muted you, but you're fine there now. Please proceed.
Yes, sir. Thank you. I was only saying in relation to the matter just discussed, can you not just put agriculture in brackets next to G and fisheries in brackets next to H?
That would seem to be very simple. That would seem to be a very simple solution. I have no difficulty with it. I leave it to Ms. Bell to determine. Thank you, Senator Wiggins. Are there any other requests, online or off? No? Fine. Deputy Chief, you have the floor. Clause 22, functions of the committee.
Chair, so clause 22 goes into the functions of the committee, bearing in mind that it's an advisory committee. The clause goes into the matters on which the committee will advise in relation to the minister responsible for commerce, on matters relating to vending policy. It will be the overseeing of the policy, assessing implementation risks, monitoring and evaluating achievement of objectives, ensuring that all government-related entities involved and considered their responsibilities, preparing annual briefings. B, they speak to the advising of the minister responsible for markets and the minister responsible for beaches, esplanades, gardens and parks, and also the minister responsible for fisheries on the following: the monitoring and ensuring continued upgrade and maintenance of vending zones, monitoring compliance of vendors in conditions on the vending zones, standards adhered to, including standards to be adhered to by the vendors, specifically in relation to personal hygiene, cleanliness, and then also relating to amenities, including waste disposal, public toilets, drinking water, protective covers to protect against weather, storage facilities, including cold storage, and the aesthetic design of stalls.
Colleagues, floor is open. I am seeing Dr. Holder.
Yes, Mr. Chairman, thank you very much. A query again relative to the sixth schedule, the constitution of the committee. I am querying, sir, having heard Minister Galinaggio's intervention earlier, the size of the committee. The authors of this bill would have envisioned that they needed someone from education, yes, technology and vocational training as well, recognizing that these three disciplines are all a part of the same ministry. If it is a case where the technocrats, if I can call them that, are of the view that these three need to stand out independently of each other, or is it a case where, because of current composition of the ministry, that we can have one individual representing that ministry and therefore maybe reduce the size of the committee? Query through you, Chair, to the CPC.
CPC, floor is yours.
The Chair, from the discussions that were had in the House, for instance, education, they were requesting their inclusion in relation to schools. In terms of technology, you wanted them included so that if there are technological aspects that could improve the operations for vendors, that they would be included. In terms of vocational training, I can't remember the the rationale for that one. But again, I think maybe Mr. Sorry? So, right. So so the thing is that you want to be able to have representation from these differing voices so that their interests could be reflected and allow for vendors to operate fully. Thank you.
Dr. Holder?
Yes, Chair, I understand the rationale. In light, though, of the reality on the ground, I know that education and vocational training tend to be merged within the same ministry. Yes, in the past we've had technology in another space, but given that education and vocational training tend to be within the same ministry, yes, Chair, we don't know what will happen in the future. How will this now be operationalized when the ministry is so notified in light of how the ministry is composed now, Chair? This may not be a question relative to the legal drafting, but in a practical way now, I would hope that it's not a case where we're inviting 3 persons from the same ministry to serve going forward.
No, I had allowed for the Deputy Chief to voice her view on the matter, but I personally think that we may be advised best to rethink this replication, especially within the context of the current arrangements.
Okay, noted.
I am pausing because I am actually reflecting here on it. You're perfectly correct in my view, Dr. Holder, that right now we have 3 on its face. It would read as though there were 3 representatives from one ministry. I'm not sure that's what we're trying to achieve. Yes, Deputy Chief.
I want to say something before Deputy Chief intervenes, sir.
Oh, sorry. Senator Wiggins, just bear with me. Oh, Mr. Cumberbatch also wanted the floor. Senator Wiggins first, and then Mr. Cumberbatch after.
Mr. Chairman, I want to say that I totally agree with Dr. Holder. And because of what she said, then because we have the senior manager of markets, then we have a representative of the ministry responsible for fisheries. So that's a duplication there as well. So I just thought I would like to bring that to your attention, sir. And I totally agree with what Dr. Holder said. You only need 1 representative from the Ministry of Educational, Technological, Vocational, and everything else. You know, I don't think we need to have 10 people representing the same ministry. So the senior manager of markets, and who in this case is fisheries, then you have a representative of the ministry responsible for fisheries. So that's duplication also. And I think a lot of this duplication has come about because previously these areas were under separate ministries, or in case of agriculture, it used to be agriculture and fisheries. So now we have agriculture under one ministry and fisheries under maritime. So I think that's where you're getting these things mixed up and confused a bit.
Chair, just to reiterate in relation to the inclusion of manager of markets and senior manager of markets, it is not a duplication. The manager of markets has a separate portfolio from the senior manager of markets. The senior manager of markets deals with public markets that are fishing markets. The manager of markets deals with another portfolio. And as I also explained, these terms are defined in Clause 2. There was a concession to trying to make, I suppose, the portfolios clear here in the schedule if people don't really want to read from clause 2. But otherwise, that is not a duplication. In relation to the other matters, I must raise a flag in relation to the inclusion of vocational training, technology, education. They were highlighted in the meetings that we had prior to this bill being introduced as persons who have a stake in the matter, and I pointed out the reasons for education and for technology. I could not remember the vocational training, but I think that we should invite the opinion of Mr. Cumberbatch from the ministry in relation to the inclusion. Thank you.
Thank you very much. Mr. Cumberbatch, the floor is yours.
Yes, Chair. When the issue of the vending committee was first discussed, and looking at what has resulted here, I think that there may be a case for the combining of vocational training and education, and therefore have one ministry representing both. But as it relates to technology, my understanding is that the thinking was that this person should come from the Ministry of Innovation, Science and Smart Technology.
Sorry, say again.
No, I was saying that there may be a case for combining the representative for vocational training and education. I think two of those could be combined. But as it relates to the person responsible for technology, my understanding is that the thinking was that person should be coming from the Ministry of Innovation, Science and Smart Technology.
Understood. So,
Mr. Chairman,
And then then there's another part duplication here at M, a representative of the ministry responsible for fisheries. I think at the time that we were perhaps looking at the fish landing sites, but we also have somebody from we also have the senior manager of markets, which is from the same ministry, I believe, Minister Humphrey.
Chair,
Right,
again,
so that is a
sorry,
duplication.
I have to intervene. That is not a duplication. Ministry responsible from fisheries is to deal with the fish landing sites.
Yeah.
They, right, and so they have to be represented from that perspective. And then senior manager of markets for fish markets, right, specifically. Those are the delineations.
Minister Humphrey, you have a view?
The Deputy CPC is absolutely correct. As it stands, the fisheries, the ministry responsible for fisheries here is for the fish landing sites, and the senior manager of markets is for markets. But given the size of the committee, I think we could, as a ministry, make one representation, and it would be on us to meet probably before the committee meets, so as to reduce the size. But not to say there is duplication, but given that we are one ministry, I believe that we could undertake to do the necessary consultation before the meeting so that the person representing the ministry can speak with some authority on both areas.
So, Chair, there was no duplication. I reiterate that.
No, I understand
Okay,
what you're saying.
but
Okay,
what
I was going to say to you that my understanding of what Minister Humphrey is suggesting is that we can, in the interest of trying to make the committee a little bit smaller and hopefully therefore more manageable, the representative for the ministry responsible for fisheries can be taken out, and at the level of the senior manager of markets, the necessary consultations will be done across the fisheries division.
Chair, I am weary in relation to that because I don't know the extent to which the senior manager of markets deals with the fish landing sites. I thought that it would have gone the other way, where you invite a representative of the ministry responsible for fisheries, and then what would happen is you take out the senior manager of markets, and then you would do a consultation to see which representative should go then.
Through the chair, I understand the concern, but the markets are by far more numerous than there are landing sites. In terms of the people we have, so the active landing sites now where we have vendors will be Pile Bay. We have, really it's Pile Bay and Pile Bay. The others, we have other landing sites, but they don't really have personnel. So we would have more markets needing representation, and I believe, given the fact that we meet so often, that the senior manager of markets could have, but I take your point, Deputy CPC, but I believe that we could have conversation and that the senior manager of markets could make the necessary representation. I do agree that the committee is too big, and that it is big, and that some compromise has to be made. So that's what I'm suggesting, not that there's any duplication, because there is none. But I'm suggesting, in the interest of the functioning of the committee, that the senior manager of markets would then have to do the consultation in-house before he comes to this meeting. If the chief fisheries officer were here, she might disagree with me, to be honest. But I think the necessary consultation can be done in-house, I think.
And I think that, having heard the minister responsible, far be it from any of us to supersede that.
Chair, just for clarity, who are we including?
Senior manager
just
of
the
markets.
senior manager of markets. Okay, thank you.
Okay, now, 1 second, please. With the colleagues online who are not speaking, or when you're not speaking, kindly remember to mute your mics. You're not running afoul of that requirement at this moment, but apparently it had been an issue at some point. Now, Mr. Cumberbatch, with respect to the thinking about the constitution of the committee, I'm hearing it being repeatedly stated that the committee seems to be on the larger side. Are there any strong feelings that were held in the early stages of the work on this matter, about which you might be aware, with respect to the size of the committee? What was being intended?
Well, initially the size of the committee was more a matter of having the wider consultation. But in relation to the legislation, to my mind, I'm still of the view that it's a little bit large. So where they could be trimming, and perhaps, I don't know if we would want to establish, because you may have a committee and then you may invite persons to make the submissions before the committee. Perhaps such an arrangement could be made. So there may be a little trimming where that could be done, but then we can still invite the views of other persons to give their submissions.
Okay, can I ask then that you, sir, please just give some time, give this some thought as to how we might restructure or have a recommendation from you on how we might relook the constitution of this committee. It may or may not pass the parliamentary subcommittee, but I think that we would do well to give this a little bit of thought as we go forward, because
Chair,
adding to it today, as we just did, it would then become almost 20 members.
yeah, Chair, just to remind the committee also that this particular committee is advisory so it is basically to collate as many of the stakeholders as possible in one place. So we do have to be cognizant of that when we are determining the number and doing our trimming, as you say. Thank you.
Okay. I'm guided, thank you. I have one observation I would like to draw to your attention, and that is that with respect to clause 22, subclause B, it says the minister responsible for public markets, the minister responsible for beaches, esplanades, gardens, and parks, and the minister responsible for fisheries will be advised by the committee on a number of things. I think that the minister responsible for commerce should be involved in that. It should be one of those people who are advised as well. I think that because the policy resides largely in the Commerce Ministry, that issues relating to monitoring and ensuring the upgrade and maintenance of the vending zones, compliance of vendors, the conditions under which they are functioning, etc. I think those are things that the ministry, with the broader policy responsibility, needs to benefit from advice on.
So, Chair, this will be, okay, so in clause 22A, we have the minister responsible for commerce on matters relating to the national vending policy. So we have those, and then what would be recommended is then the minister responsible for commerce also be added to B?
Yes.
In spite of the A?
Yes.
Yes, okay, thank you.
For the avoidance of doubt. In other words, as you go deep into the belly of the provisions of subclause B, you're getting into things like waste disposal and sanitation matters and so on, protective covers, etc., etc. Things that might not always be top of mind in the Commerce Division, but do impact the policy.
Madam Chair, Chairman, sir, sorry.
I don't mind being called by the wrong title. For example, I've heard president, etc. But if you're going to say madam, I'm going to have strenuous difficulties with that.
Sorry, sir. Normally, in this place, when I say chair, it's normally Madam Chair. I apologize. But I saw the hesitancy in the deputy CPC, and I am now inclined to agree that perhaps we should then, given what you just said, take out senior manager of markets and leave a representative of the ministry responsible for fisheries, which would also include senior manager of markets if necessary, because it seems there are wider issues that would also be consulted on here. So I would remove H and leave M.
I want to just say this though. The reason why I just want members to recall, Minister Ford is not with us at the point, but one of the concerns we had with respect to the supervisor of markets and the senior manager of markets was this question of the evictions, relocations, that day-to-day management of the process. And yes, because there's nobody else who can really speak to those issues outside of the senior manager.
That's what I'm saying. I mean, given the committee, because the representative of the ministry responsible for fisheries would still be, on my recommendation, the senior manager of markets. But in the instance where there are wider considerations, I just heard you speaking about other things, it would be, I think, in the ministry's interest to have a lens that's zoomed out somewhat, so that the representative of the ministry responsible for fisheries would more than likely be the senior manager of markets. The challenges going to arise in the Ministry of Agriculture because they don't have two instances of markets. Where I have markets and they have landing sites, they just have one. So their manager of markets is going to cover everything they need. In my instance, I have markets and I also have fish landing sites, which would both require some consultation. But if they're advising the minister responsible for fisheries, I think it wouldn't hurt to zoom out somewhat, because the representative responsible for fisheries would be the senior manager of markets. If we were to do it the other way around, it would mean that I could have no other person other than the senior manager of markets and nobody else in fisheries. But I suppose it's somewhat intellectual.
May I suggest then, Minister, that much like Mr. Cumberbatch, that you two give some thought to this, and we can always be advised as to what your
Yes, sir.
formal position is.
Yes,
But,
sir.
colleagues, it may well be that even though this committee at first blush does appear to be very sizable, for the practical purposes that we've all been pointing to, it may be impossible to get the benefit of wide consultation and advice, and at the same time not maintain the size of it. So, well, yes, and as the clerk of the House makes the point, there's really no inherent problem with having a large committee. Okay. Are there any other observations sought or interventions sought on 22? If not, we go into clause 23, please. Appeals, part 8.
Mr. Chair, I just want some clarity. I don't know exactly which part of provisions such as this, but I think it's should be placed. But I believe that there's a major conflict that the state is failing to address, while giving the impression to both Maritime and to the NCC that they have any right absolutely to control vending on beaches. Private sector is claiming under a convention called accretion that they have rights, conventional rights to extended right down to the high water mark on the beaches. And when NCC or any of the government agencies attempt to assert themselves, they are laying claims under this so-called term accretion to private ownership of the lands extended down to the high water mark. Therefore, when the NCC enter into an arrangement with the vendor to put chairs on certain areas on the beach, the private sector is saying, no, this is our property. In some cases, the private sector puts chairs and block off the entire beach and obstruct people on the beaches. And they're arguing that they don't have to have the approval of an institution that is protected under statute, and allowing a convention to overrule statutory law. And I believe at some point, I don't think it's a matter that can be easily resolved here, but I think that the luminaries, the academics, or whoever, we ought to address these issues, because sometimes I get the impression we are withdrawing from facing some realities because of a fear and believing that we're going to disrupt the order. So I would like to know if it is the view of those who are responsible for drafting of giving some clarity to the authorities of the state, which is in this case Maritime Affairs, NCC, Coastal, and those beach lands. If it is clear that where the Maritime Affairs or where NCC has the legal authority, that conventional practice must play a secondary role to the legal authority that is vested in the three state agencies' hands. I think it's a matter, I'm not talking about coconut trees now, but I think it's a matter that we have to address, because we have that problem now on all the coastal lands, especially with people putting up chairs, and then the only body that NCC can assert themselves in dealing with is small people. But when big people do the same thing and abuse the law, they can continue to do it because the state backs off and allow them to do what they want to do. So I would like to believe that we will have some discussion at some point, and I don't know if in the property law or if it's in the law related to vending, we need to address these issues, but I think it is something that we should consider.
Chair?
Or is it an issue with the state?
In relation to the original presentation that was made, under clause 5 6. It was it was made clear that a person carrying on a hotel, restaurant, or other business in respect of which there is a existence of a valid liquor license, that they would be required to apply for a vending license under the present legislation, and they would be applying to the NCC. This is the preservation of a power that was once under the NCC Act. So that area has been addressed. Thank you.
This is in relation to liquor license.
Chair, just to be clear, we imported what was under the NCC Act and put it in this piece of legislation so that the NCC would have the authority to deal with hotels that carry on their business near the beaches and other areas that were covered by the NCC in relation to vending. But there was the other part in relation to the liquor licenses that we also were asked to preserve, which we did. So I am just saying that there was an active preservation of the NCC's powers in relation to these entities. Thank you.
All I'm saying is that at present, there is a wide complaint on our beaches by persons who are asking for permission to carry on a business, having chairs on the beaches. They apply to the NCC. The NCC grants permission, but lots of the people in the private sector who owns beachfront land don't believe that they have a duty also to apply to NCC to ask for permission to place beach chairs on the lands adjacent to their property that is extended down to the high water mark, which is classified as accretion. I'm just saying that to me, it seems as though there is preferential treatment. That is the general discussion on the beaches by ordinary people, and I'm just asking if this legislation is the appropriate legislation that we can use to address such a problem. I'm not trying to make things complicated. I'm just asking if we can resolve it, because it has happened more than once while I was minister. Before that as well, I had to venture to the beach where business people decide this is my area of land. Men came out with loudspeakers and said, this is my area of land, and I don't have to ask NCC for any permission. And they told people who were in their restaurant, you can't enter back in here as long as you deal with vendors on the outside. They don't have the authority. And I'm just saying that we need to address it. I'm not saying that you must address it in this piece of legislation.
I follow you,
but I just need
member.
Clarity on, but we have to address it.
I follow you, honourable member, and I would want to suggest to you that perhaps the better piece of legislation would be the National Conservation Commission Act.
No, Chair, sorry. I really do have to intervene. Again, that part that gave the NCC that authority was transferred into this legislation. And I went through pains to explain how it was incorporated. And so I am saying that I have provided the response that is required. The legislation provides for the enforcement mechanism, and the obligation has been created, and the power to regulate has been created. So I am not really sure what is the issue. Thank you.
If this right exists, does it exclude the claim that is being made currently about the right to accretion? Is it on the general principle of statutory law preponderates any kind of conventional practice, and therefore it stands? I'm just trying to find out that, because we're not writing narratives here about fiction.
And what I very humbly would wish to draw to your attention, and indeed to remind the Deputy Chief Parliamentary Counsel, is that the vendors bill does not in any way, shape, or form begin to address the issue of accretion, nor should it be taken to the extent that it will address those issues or any derivative thereof. I think if we keep this within the, as we like to say in Barbados, you hold your lane. Let's keep our lane. Make it very simple and easy for everybody to understand. No doubt, Honourable Member for St. Michael East, you're raising substantive issues that do in fact exist, but they will not be fixed in this piece of legislation.
Okay. Understood, sir.
Okay. Now can we move to Part 8, please? Appeals, Clause 23.
Chair, Clause 23 speaks to the grounds for appeal, and a person who is aggrieved by a decision of the minister, a decision of the commission, or a decision of the manager of vending zones may apply, and there are the specifications for the grounds for which they can apply. So that is basically the substance of that provision. Comments?
Okay. Colleagues, I'm not seeing any request for an intervention. As they say, going, gone. Please then, can we proceed then to Clause 24?
Chair,
Sorry?
Clause 24.
Sorry. Go ahead.
Clause 24 speaks to the establishment of the National Vending Appeals Tribunal. It speaks to the composition, the tenure, in terms of appointment and reappointment, and remuneration. Comments?
Colleagues, any issues relating to the establishment of a National Vending Appeals Tribunal? We have the composition of the tribunal, we have the tenure, we have the opposition on the floor. Please proceed.
There's a query, I don't see it in 24, I know it follows under where. Is there any provision stipulated here with respect to a time frame within which the National Vending Appeals Tribunal should meet and dispatch or dispense with matters before it? Ask that against the backdrop of what now obtains, where people with industrial relations problems can't get their matters resolved in good time. Tribunal is not meeting, there are all kinds of excuse explanations, there's no facility wherein we can meet this and the next, and delays and protracted delays, and people's matters are not heard to their significant disadvantage. Are we going to repeat this? You will not bring that kind of situation to obtain with reference to this matter, I'm sure, Minister. But what undertaking assurance there is, if we fall short of a guarantee, what assurance is there that appeals will be disposed of in good time, such as not to disadvantage people we're trying to empower?
I take the point, Leader of the Opposition. I think that this will be a matter that would have to be dealt with by way of regulations to the legislation. I
Chair?
don't know that it could tightly be dealt with here. I hear the CPC on it. Please proceed.
Chair, just to say that in Clause 23, the persons who are aggrieved in relation to the decision of the various functionaries may, within 14 days of the receipt of the notice of the decision, appeal to the tribunal. So that is the one of the timelines stated. As you would have articulated, the general procedure may have to be fleshed out in regulations, and the power has been given for the minister to do so.
Right.
I see that, Mr. Chair, with your leave, but that's the time frame within which one can give notice or make an appeal, but to have the matter disposed of becomes another issue.
And it is to that I was speaking. And I think the CPC is also pointing you in that direction, that I think it is clause 37 of the bill allows the minister to make regulations, and quite rightly, what you are seeking is a provision, sorry, not 37, clause 34. And what you are seeking is a provision which will facilitate a finite and defined time frame within which these appeals are administered.
I just wanted to make another point. Sir, this thing about restricting people from, in the tribunal, from being a participant if they have less than 10 years experience. It is strange that a person who, with a specialty, have been an outstanding scholar in this specific area, would have to wait 10 years before he is perceived as qualified to serve on the tribunal. There are some people that spend 10 years in service and never reach the level of some persons that spend 10 months in the service. I would like to see an area where a person has the appropriate specialty that they can qualify on merit. Not 10 years don't necessarily mean that is based on the judgment of meritocracy. You can be in 10 years, 20 years, 40 years, and you still can't perform at the level or still can't even understand the complexity of some of the public issues that are likely to come before us. And at least there must be somewhere, something else that we can do. That if a man comes in, he's well qualified, and we know that he's well qualified, there are always ways of finding out if he's well qualified to apply the appropriate judgment and understanding to these things, that he should not be debarred from participating because he does not have 10 years experience.
Honourable member, I would be the last person to have a challenge with meritocracy, but I think you would appreciate that even as the legislation speaks to an attorney at law of 10 years standing, what the attorney is being asked to demonstrate, hopefully by that 10 years period of time, is that he or she has developed some level of experience and expertise. Equally, with the vendor of at least 10 years of experience, one is hoping that you become familiar with the business of vending in all of its shapes and forms across the island. If there was a more objective standard to be offered, I would be happy to hear it, but in the absence of that, what do we do? While you mull over that answer, let me hear Senator Sands, please.
Right, dealing with the same point, Chair. While I understand the point as you just related with the attorney at law of the 10 years, my difficulty here, and I guess Deputy CPC can assist me here, when we deal with subsection 2B, clause 2B, a vendor of at least 10 years experience, how exactly do we measure 10 years experience? Because by definition, a vendor is a person who has a license. By the definition, we would be assessing a vendor as a person who has a license. So would the 10 years be based on 10 years continuous holding of that license? Is that what we determine to be 10 years experience? Because we're narrowing back to the definition of what is a vendor. And if we check the description of a vendor is a person who has a license, as opposed to just a person who has been in the practice of vending over 10 years of time and now has a license, and we're assessing them not necessarily based at the point at which they received the license, but based on the overall time they have been in the practice of vending. that is my concern as to how do we measure 10 years experience. So I guess Deputy CPC could give me some guidance there.
Chair, it was really supposed to be assessed based on your practice as a vendor, so that was the thinking. But I understand what is being pointed out. It is just now, how do you get the person with the requisite experience? How do you reflect that? So then the thing is that I would need some kind of policy directive in order to for you to attract the right type of person to be sitting in this chair. Thanks.
Chair, if we look at C, a person with knowledge and experience in business of vending and the operation of markets, would it not also overlap them with the same a vendor of 10 years experience? Point here.
Question asked and answered.
Indeed, Chair.
Good. Go ahead. Ms. Moore?
Chair, we didn't have the pleasure of hearing.
Oh, I beg your
Those of us on the
pardon,
line.
Senator Holder. The observation was that a person with knowledge and experience in the business of vending may not necessarily be a vendor. And so therefore, the difficulty of a potential overlap doesn't necessarily arise.
Chair, my mind was just going to the Employment Rights Act, for instance, where a tribunal is established, where you have an attorney, you have an employer's representative, you have an employee's representative. And I'm wondering if the way to get around B is to suggest that the person is selected from among the vendors, like Barvin or whatever the other associations may be agreed, and that may come up from time to time, if they get to choose their own person to sit on the tribunal, because that's how it is done and it is effective in other areas of the legislation. So without stipulating, because certainly an association will choose from among the best that they believe exists to represent them. So I'm just wondering if that's not something that we can look at.
Or so one hopes. The suggestion. Agreed. The suggestion then, Honorable Member for St. Michael East, is that we could have 24(2)B replaced by a vendor selected or chosen by the Bar Business Association of Vendors.
Chair, just in an organization which represents vendors, make it more general.
Oh, sorry,
Yeah.
an organization represent. Yeah. No, the only danger there is that there are a plurality of organizations representing vendors. So how do we determine which organization is the one that will do so? I don't know that such a thing exists. I don't. It is. I'm hearing you, but I am being. I am being very serious about it. I do not know that that is possible given the lay of the land at the moment, because of the very informal nature of the whole business.
According to the draft, though, what was before us, a vendor of at least 10 years experience, who was doing the selection in any case? Where was this person, how was this person to be decided? By who?
Chair, the minister was supposed to do the appointment, so that is how it would be done.
This is appointed by the minister, correct? Yeah. So the minister in his discretion was going, what the proposal would have been for the minister in his discretion to determine or appoint a vendor of 10 years experience. Going back to Senator Sands's question, it would have been a vendor who has been holding a license for 10 years, at least. Now, the issue is if we're going to depart from that line of thinking, I have no difficulty with that, but let us not make it unduly cumbersome. If we're going to have it as a representative of an association of vendors, I think we have to choose the association or find a way of making sure that the association is representative of the broad community of vending, which at present seems to be difficult. No, I'm quite happy for this to be a matter that we put before the vending community when they come to give evidence.
Because you have Barvin, you have them at C&D, right? Under the constitutional committees. Association of Website Vendors, we have them listed. And we have the Barbados Association of Vendors, Retailers, and Entrepreneurs. So I think you're right, Chair, that could be a matter that's discussed with them. I personally don't like the idea of any minister determining for vendors who will represent them on a tribunal. The minister shouldn't like it either.
The minister has listened to the honorable member's tone and is properly schooled. No, schooled and scolded. I see Senator Holder's hand.
Yeah, thanks, Chair. Actually, we just about to lower it because the last intervention by MP Moore is actually what I wanted to suggest. I know, Chair, that from your experience over the last year and some in the sector, you're aware that this is a challenging undertaking. Unlike the example given by MP Moore with the Employment Rights Tribunal, those agencies are well structured, good governance arrangements in place, etc. So, you don't really have a challenge if you're very practical. There's a high level of informality in the vending sector, and so that could easily be a challenge. So, Mr. Chairman, I understand your concerns, but it would be interesting to see if we're able to get the two, because there are mainly two that represent the majority, if you will. If we can get them to agree on who that person should be. Failing that, Minister Simmons, with responsibility for commerce, may have to make a decision. Yes, we don't like a minister appointing persons to the tribunal, but in a case like this, if we are unable to draw on another model, we may have, sir, to look at 2B as a person with 10 years, at least 10 years vending experience.
You noted, Senator Holder, the challenge really would be how do you formulate that view into. Look, before we go there, let us give ourselves the benefit of having the consultation on this point with the community. That way we will be able to question them, get an understanding of how structured they really are, what their thoughts on the proposal are. I think we do ourselves a lot of good if we just defer this particular point until when we've had an opportunity to have it more appropriately ventilated, more fully ventilated. Is that agreed? Fine. Senator Cummins, did you want the floor? Sorry, Minister Cummins. Is Minister Cummins there? She's gone. She's online, but does not appear to be with us at this time. Okay, we will go then to Clause 25.
Chair, Clause 25 allows for the suspension of decisions of the various functionaries, being the minister, the commission, the manager of vending zones, pending the appeal under Clause 23 on application of the appellant, and suspend the operation of the decision until the appeal is determined.
Colleagues, this is not a difficult clause. This clause effectively is saying that if you are minded to appeal the decision made by the minister, the commission, or the manager of vending zones from against whom you are appealing, those decisions are stayed until, or suspended rather, until the appeal is determined. Any issues with that? None. I proceed to clause number 26. Power of the tribunal. Deputy CPC.
Clause 26 deals with the powers of the tribunal. So you will see that there are interventions that can be made in relation to changing of decisions or directing of certain actions in relation to the decision. You can allow certain appeals, dismiss certain appeals, confirm certain decisions. In relation to compensation, you can set aside an amount and substitute for an amount of compensation. So there are a number of powers that the tribunal has pursuant to this clause. So if there are comments, I'm obliged.
Colleagues, are there any interventions being sought under this clause? And then?
Chair, Clause 27 gives the power of a party to appeal the decision of the tribunal on a point of law to the High Court. So that's basically Clause 27.
Colleagues, appeal to the High Court. Honorable Member for St. Michael East, appeal to the High Court.
Correct practice needs to be followed on at this point.
Yes.
After the tribunal made the next caucus that is appropriate is the High Court.
Fine. No issues.
No issues.
Okay. Okay, we move then to Part 9. If I am not seeing any other requests for the floor. Part 9, administrative penalties.
Clause 28 speaks to just the general provision on administrative penalties. So where a person contravenes a provision as set out in Part 1 of the 7th schedule, they would be liable to pay the manager of vending zones a penalty, an administrative penalty as set out in the 7th schedule.
Any requests for the floor? Joe? Okay, clause 29.
Clause 29 requires the manager of vending zones to issue an administrative penalty notice if they find that there's a contravention. The nature of the form of the notice is set out in the 7th schedule. The notice will specify the nature of the act, the penalty to be paid, and it will be a requirement to pay the penalty within 14 days of the date of the notice. A person who is in receipt of the admin penalty notice shall pay the amount of the penalty set in the notice on or before the date specified in the notice.
That is clause 29, subclause 1 through 3. Colleagues, any issues, or can we go to clause 30?
Yes, Chair, just a query.
Senator Sands.
I don't know if it would be appropriate for clause 29, but while I know that the person would be asked to pay a penalty, is it possible within the law that in circumstances where a person is unable to pay the penalty in full, that there could be provisions for a payment, not necessarily a payment plan for lack of a better word, but somewhere that you can indicate within the law that there can be a structured payment settlement that would be open to the vendor to negotiate with the manager of vendors. So in other words, if I can't pay the full amount of the penalty by the specific date, is there a way that through the law I would be able to pay over a period of time so that I am not in breach of the penalty? That's my query.
You wish to take a reply, CPC?
Chair, a provision can be inserted to give that kind of a discretion.
I personally have no objection to such a provision being inserted. I think it would be humane in keeping with the spirit of the legislation. In these matters, I'd like to defer to the views of the Honorable Member for St. Michael East. I don't know if he wishes to go on the record on this issue.
No, Mr. Chair, you are correct. I always believe that when we structure legislation knowing very well the category of individuals, the class of individuals, the social standard of individuals that are going to be affected. And therefore penalties, you have to take all that still into consideration, especially if the principles are undergirded by some kind of humanism. And you hear me use that word over and over again because it guides me. Sometimes people just get up and say, you will have to pay within a certain period of time. You know, it's almost unrealistic. So the only thing that you can be doing is to take, you got to go another stage in order to penalize the person in a severe way, simply because they can't pay at this specific time. So I really I'm really admiring the young senator for at least attempting to address the humane concerns in the legislation itself. This is not a draconian or colonial period where we just maybe want to penalize some person. You go to the extreme where so you hang it. You don't hang a man for not having a bicycle belt. You have to always be reasonable in your judgments and see how you can apply the legislation. And that is why sometimes I hold a position which is not critical of any specific person. I am equally as loving to that person or any other person when I finish having discussions, because it is just reasoning. And I might just have a style that might be perceived by social types as an aggressive and militant style, but it is probably I am more loving than many persons can even imagine, sir. Well, I really believe and support the proposal that we have that provision in place, that if persons cannot pay the lump sum, we will allow them a reasonable period of time to pay in small installments.
Honorable Member, none of us in here are able to bear testimony to the best of my knowledge of the extent of your amorous nature, so we take you at your word. The Honorable Leader of the Opposition is suggesting that there may not be much in your reputation that substantiates this view that you proffer, but that is not germane to these proceedings. I think then we can agree, Deputy Chief Parliamentary Counsel, that we could write into the legislation some provision for these payments to be made by way of installment, and the nature of the installment and so on would have to be determined. I would imagine you will make the appropriate recommendation to us. Now, I think then we go to, is it clause 30 or 31?
Clause 30, Chair.
30, okay,
So,
fine.
Clause 30 makes provision for challenges to administrative penalty provision under 28 and 29.3. Sorry, but basically what it is making provision to do is that if there is an issue with the administration of the administrative penalty, then that person may appeal to the tribunal in accordance with section 23.
Does anyone seek the floor on this matter? I see no hands. Please proceed then to clause 31.
Clause 31 speaks to the fact that any outstanding administrative penalty constitutes a debt to the Crown and is recoverable in civil proceedings before the magistrate's court.
I had wanted to do. Floor is open, colleagues. Administrative penalty to constitute a debt to the Crown, recoverable in civil proceedings before a magistrate's court. Fairly standard, no problem. Part 10, miscellaneous provisions.
Chair, and clause 32, the fees collected by the minister responsible for commerce shall be paid into the consolidated fund. The fees that are collected by the commission, this is the NCC now, shall be retained to the commission and shall constitute the funds of the commission as set out in section 10 of the NCC Act, Cap 393.
Colleagues, are there any requests for the floor? None. Let us then proceed to transitional provisions, clauses 33, 1, and 2.
Chair, it's an attempt to deal with those licenses that would have been issued under the NCC Act and the Markets and Slaughterhouses regulations, that those licenses will be valid for a year after the commencement of the Act. And then in subclause 2, then after the expiration of that period referred to in subsection 1, the person seeking to operate as a vendor shall then apply for a license to do so under this Act.
Fine. Grateful to you, ma'am. Are there any requests for the floor? Any interventions proposed under clauses 33.1 and clauses 33, subclause 2? None? The next three regulations, 34, the minister may make regulations generally to give effect to this act. We've discussed that myriad times today. 35, amendment of schedules, and I think the deputy chief has gone through the schedules in some detail already. And 36 is consequential amendments, which come about as a result of the passage of the Act. Now, there is a matter which I wish to put before the committee. I raised this in the closing parts of my first reading speech, and I want to be faithful to that which I said to the House. It is my judgment, and I think it is supported by some of the members of the Parliamentary Council of the parliamentary group of the governing party, that we should attempt to use this opportunity to expunge all convictions previously made against the vending community. Now, that is a matter about which I seek guidance, CPC, because quite frankly, it was not within the contemplation of this bill. I am not sure if it can be done in this bill or if it will have to be done in a separate piece of legislation. But first of all, before you advise on how it can be achieved, what I would like to do is to have the views of members of the committee, as opposed to the parliamentary group of the Barrios-Lay Party, the members of the committee, what your feelings are about expunging the records of all of those people who have carried criminal convictions for vending prior to today. Floor is open if there are any views. I didn't think it would be, but
Chair, I suspect that the silence is just all of us in total agreement with the position that you have espoused, sir, that we should expunge such records.
Chairman, I am online and my hand was raised.
I am sorry. I am only now seeing it. I beg your pardon, Minister.
Thank you very much, Chair. I wish to wholeheartedly endorse the position which you have just put on the table. I think that the notion of criminalizing and decriminalizing an activity like vending in the context of this bill is perhaps one of the most seminal things that we could do, in addition to providing rights and a framework within which they may operate. And I think perhaps if the CPC can, Deputy CPC can so guide, I too would be interested in hearing whether or not that is something that can be done as a consequential amendment, and we can go back and treat to that as at the past, and then we would have righted all future wrongs by way of this current legislation. So my wholehearted support is thrown behind it, Chairman.
Thank you, Minister. I have heard sort of okay from the leader of the opposition. He has no objection. Senator Wiggins, you have the floor.
Mr. Chairman, need to be guided by you on the question that I'm asking. If that is a proposal that you are putting forward now, is it possible that it can be included in this bill rather than letting this bill go forward as is to be passed and then come back and make an amendment? Because truthfully, that would be a substantial amendment if you intend to expunge all the wrongs, if you want to put it that way, of vendors in the past. So is it possible that it can be added? In my simple way, I'm asking that question.
No.
If it is possible that it can be added to the bill now, rather than passing this and then doing an amendment, which makes it tidier.
Your question is understood, and perhaps I had put it badly, because that is effectively what I was trying to find out from the committee. First of all, whether you were in agreement with the idea, and secondly, to invite the Chief Parliamentary Counsel to advise us on whether it is possible to do it in this particular piece of legislation, or whether we have to adopt a different course. So, I'm not sensing that there's any resistance to the idea, other than that I see the Honourable Member for St. Michael East wishing to take the floor. I cannot imagine that he is objecting.
Certainly not, sir.
Oh.
It is not to be just not to be perceived. It is not to be perceived as just a simple, probably the words don't fully express how important this decision by all the members of the committee and parliamentary group, and I've heard these views expressed as high as the leadership of the institution, and certainly we're hearing these views being expressed by the leader of the opposition and many other reasonable persons in the general public of Barbados. These records,
reasonable people. The
reality is, sir, that when these criminals, for these minor offenses, misdemeanors, many times these encumbrances serve to stop that person from making any form of mobility in life and not having access to work. And in some cases, they used to even stamp them in the back of your passport when you're leaving to go overseas, and it used to be, obviously it wasn't there just for decorative purposes. It used to leave a negative stain on the psyche of the individual and stop a lot of persons from getting basic jobs. Sometimes when somebody asks for a police certificate of character and you just had a minor offense, this destroyed the entire livelihood of the entire victim, and I say victim deliberately. So it worries me to know that we took so long to be able to expunge these records of persons who have been accused and to some extent being labeled as though it's a criminal offense. Obviously, if you commit a criminal offense, people see it as a criminal. So I'm glad to know that at least we are taken into consideration, and I hope that we can record it in this committee, and that what is recorded in this committee, whether it is reflected in this piece of legislation or not, that we take it as far as the House of Assembly and come to a decision about the urgency of expunging the negative records of persons who are vending and so on. I really look forward to seeing that. That would be a very, that's what you call it, right? Special day, a glorious day? Or what a glorious day it will be? What a day that will be. So I strongly support it, and I'm sure that all other members share the same view.
Fine, thank you, Honourable Member. Deputy Chief Parliamentary Counsel, can you advise, please, as to how we might achieve this?
Chair, so the pilot ministry was advised that in relation to the procedure for expungement of criminal records, that is addressed in the Criminal Records Rehabilitation of Offenders Act, Cap 127A. And so therefore there exists already a mechanism for such expungement.
But how do we get from this point to that? What do you advise then that we do? What are the steps that
no,
we
but
have to take?
there's already a piece of legislation involved. So the thing is that the persons who have such records may proceed under the appropriate legislation as cited. So a mechanism already exists providing for expungement. That's what I'm pointing out.
Oh, but that would have to be done on an individual basis, case by case basis.
Yes, Chair. According to you would have to do it in accordance with the existing piece of legislation.
Not a lawyer, of course.
Chairman, I have
But the Leader of the Opposition had the floor. I note your desire to speak, Minister Cummins. No, proceed.
I'm saying I'm not a lawyer, but can't you simply write into this legislation a reference which makes a link with the existing legislation? So this properly belongs here. You don't have to rewrite the law, but at least you provide for it.
And that is exactly my concern. I can't recall from the top of my head where I've seen it, but I am sure that I've seen at some stage in the last 20 years this a step taken where the legislation on passage then repeals convictions which have taken place before.
Chair, but if you have a mechanism that already exists for such expungement,
I want you to try to bear with me, Deputy Chief. You are thinking purely legally, and I know that you are on good ground legally. There's another dimension to the thinking taking place here, which is a very social dimension. What we are trying to do is to remove the stigma that the honorable member for St. Michael East has pointed us to from the name of those people who have been given criminal convictions. And what we would like to be able to achieve is, with a broad brush, put that whole sordid history, which has been part of Barbados's evolution, put that behind us at one time. There are some people who would have died and gone to the great beyond carrying that burden. They cannot come and clear their names now by an act that they're taking consciously under the Criminal Records Rehabilitation Act. But if we can do this for them, then we have done justice. That's our thinking.
So a provision would have to be created to recognize that class of person. That class of person would stretch over different pieces of legislation. So it would include markets and slaughterhouses, it would include NCC, it would include all the relevant enactments and it would have to be starting from the coming into operation of those enactments. That is the structure that you would be looking for.
I think so. And the only thing I could add usefully to that is that even if it was possible to do it before those enactments, but I don't know the legislation under which, but I have an idea of some of the pieces of legislation which they would have been convicted under, but I wouldn't know all of them. But the reality is that where our minds are at, if I could speak for the collective, is that we recognize that throughout the annals of the evolution of our history, they have, since 1700, 1800 and going on, there have been people who've been convicted for this business of vending. And what we would like to do as robustly as possible is to extinguish, expunge all of those records. Now, if it can only be done practically with the Market Slaughterhouse Act and the National Conservation Commission Act, etc., well, fine. But ideally, we want to be as broad and all-encompassing as possible.
Chair, you would have to say all enactments touching and concerning, well, you wouldn't say touching and concerning, but touching and concerning the subject of vending. I would be cautious, but I have some reservations.
I have given you. I would like you to add that to your homework and advise us, please, on how we can achieve this.
So we go right back to the 17th century.
As far as I'm concerned, we should.
Yes.
But I recognize the challenge legally because there were different pieces of legislation, and you can't very easily do it without identifying the legislation under which people were convicted. But if the deputy chief is able to, then this is where we will spend some time when next we reconvene. Well, or should I give you an extra day? Because we can come back on Friday as well.
Chair, there are several other areas to prepare for, so I can try to get it done by Friday.
No problem. I'm grateful to you. For those online, the Deputy Chief Parliamentary Council is undertaken to try to put us in a position by the end of the week to have a form of words that we might use to achieve this very important undertaking. Now,
Chair, and historic research has been done on a whole set of acts. I was just asking my comrade, because he has some knowledge of that. Professor Beckles, Dr. Beckles has done extensive research on all the acts between 17th century and now, and I think that we try to capture it by making reference to the specific acts that he has recorded. If there are any others, research can be done within the next 48 hours, so the information can be made available to the deputy.
Honorable Leader of the Opposition, the Honorable Member for St. Michael East, I agree with you. Thank you.
Sir, I noticed that you're intimating we would like to meet again on Friday. Just wanted to say that's all right with me, because I recognize there is some timelines attaching to the deliberations of this committee, but there's also some important work with the Public Accounts Committee that we have on hold. So I personally, as chairman, would want to suggest we would accommodate this Friday. We've been using Fridays, but I'm not too sure about the Friday after that. I'm just alerting you.
I'm very grateful, Honorable Member, and I assure you I would like to be able to be finished with that by next Friday.
All right. With respect, if you don't mind, you went so quickly on schedule. It's a schedule 4. It's part 2 vendors license. Is there usually expiration date attaching to these indicated on these licenses? This has date of issue but no expiration. Is that normal?
I think I speak subject to correction, but I believe that the licenses last for a year in each case. So the expiration
shouldn't be form indicate that. Shouldn't be. That's not on the form. The black.
Assist us, please, Honorable Member. Which schedule?
I'm on page 40. I think it applies to other than page 40, but page 40, and this has to do with the vendor's license, vending license for vending in operating on beach, esplanade, etc. Date of issue is given, but I don't see expiration or expiry. I don't know if that's the normal format.
I would not want to hazard a guess, but my gut instinct tells me that if the license is an annual renewal, then if it is issued on the 1st of June, then it's valid until the 1st of June.
Thank you, sir.
Or 31st of May.
Page 55, perhaps more substantially. Page 55, it has to do with vending zones. Page 55-4, and I looked through that, and the geography takes me down Roebuck Street, across Country Road to Baxter's Road, and then left. And I wonder why we would have gone through Country Road rather than down Roebuck Street, across Pinfold Street, capturing White Park Road, and those areas at the back of the library that bring us back to Baxter's Road. A lot of vending goes on in those areas.
Chair, just to respond, these particular areas that are cited in Part 2 are directly lifted from the markets and slaughterhouses regulations, so that's why they appear in this form. So that's where it comes from.
Point, Mr. Chair, but all I'm saying is a lot of vending takes place beyond Country Road where you turn right to go towards Baxter's Road. A lot of vending takes place.
I think you're missing the point, Honorable Leader of the Opposition. I think that what the Chief Parliamentary Counsel is saying is that this was lifted from what existed, but there's an abundance of room, including within the remit of this committee, to broaden the scope of the zones. Yes, and I am agreeing with you. So we will come to that. We will come to that. Senator Cummins, you wanted the floor.
Thank you, Chairman. Through you, I'd like perhaps to request the Parliament to provide you with some assistance with regard to those of us who are online. I think I requested the floor some time ago, but without us being physically present, it seems as though we're almost invisible. And so the discussion proceeds very quickly, even though we have requested the floor and indicated we wish to speak on a particular matter. So now we're well past where I wanted to intervene. But that notwithstanding, maybe in time for the next meetings, the staff from Parliament can assist the chair with ensuring that those of us who are online are recognized. Chairman, on the question of the point just raised now, since I'm going to abandon my earlier point, since we've now moved on, page 4, I just wanted to ask a question, a procedural question more so. We've now come to the end of the substantive sections of the legislation, and we're now moving into some examination of the schedule. We agreed that we were going to have a number of persons who would come in and make submissions. What is the proposal for us going back over the actual substantive clauses of the legislation subject to the interventions of the persons who will be invited to present before the committee. I just wanted to understand where we're going from here. Now we've ended our consideration of the last clause in the actual bill.
One moment, please, Minister. I think, I'm not sure if it is related to the opening concerns that you voiced, Minister, but I sense that the staff at Parliament would prefer, as we go forward, to have the background, which is the official background for parliamentary online participation, being utilized. Does this apply to the Senate? The Senate uses it? The Senate does online?
No, we do not.
No. Okay. Okay. But I think then that that background would have to be accessed by the senators. Okay.
So background notwithstanding, Chair.
No. I'm coming to you. I think you may have actually jumped the gun there because we have to deal with this matter now as part of the housekeeping as we go forward. I'm proposing for us to begin Wednesday morning at 10 o'clock. And as I understand your question, you want to know whether or not we will be going through this substantive legislation again.
That is correct, Chair. If I'm using the example of the Joint Select Committee on...
I think we probably revisit pieces of it, but I don't think we're going to go through it clause by clause as we have done. This was for the members of the committee to have their input and so on first. We're now going to come to the stage from Wednesday morning where we will have, I believe we begin with the Barbados Association of Vendors. We will start to take oral evidence from people who are stakeholders, and we will also deal with the written evidence, for example, that has come from your ministry. And mind you, let me pause to ask whether you would wish for an officer of your ministry to participate orally as well. Would you?
Yes, we can absolutely facilitate that.
Okay, fine.
Chair.
The clerk will make the necessary arrangements for that and time and so on. But the intention then would be that once we come to the oral participation, we would then have the committee, if it is that the participating entity has submitted something in writing, we will have it distributed beforehand, treat it as being read, and allow for members of the committee to question those persons who have made their submissions in writing in the context of those submissions and also against the backdrop of the legislation, because obviously they are writing out their understanding of the legislation. It may be helpful, I think, if people who have done a written submission perhaps be invited to share in a very thumbnail sketch kind of way the type of or the substance of the submission that they are making or that they have made. But I am mindful that for some people that may mean reading through the whole submission, and I'm not really minded that we take up a lot of time doing that. I prefer for it to be circulated for members read, and then if it is that somebody is being a little bit too laborious in their presentation, we just get straight into the questions and get to the pith and substance of what it is all about. If that satisfies your question, then the next issue for me would be how we deal with the Wednesday morning and Friday, because I'm looking at us meeting at 10 o'clock on Friday as well. My proposal at this stage would be to begin with Barvin. I am not sure how many people will make submissions under the umbrella of Barvin, but I think that we could adequately deal with them between 10 a.m. if we start punctually and lunchtime on Wednesday morning. In the afternoon, I know that we already have Ambassador Commission has made a submission. He's made a submission and he's made a request to have an oral presentation, and I look forward to the contribution from Ambassador Commission and the honorable member for St. Michael East. Yes. Yeah, we will reach out to Ambassador Commission to find out whether he's able to do it on Wednesday. In the event that he cannot, I would want to suggest, Minister Cummings, that you have your people from the BTMI on standby, that they could do it on Wednesday afternoon. And that probably would be, I think we could use the times we used today. So let us say from 1:45 onwards. Ideally, we should be finishing by 3:30. We have gone a little bit past that this afternoon. All right. Now, there is another association of vendors. I do not want to presume that Barvin speaks for everybody. I'm trying to remember the name of the other association. Wayside? Yes,
Wayside vendors.
And I would want to make assurance doubly sure. I know we've reached out to Barvin. Have we reached out to the Wayside Vendors Association? If not, we must do so, please. At the soonest possible opportunity. Now, Mr. Clark, are there any other submissions that have come in thus far that we can then try to? Not as yet? All right, fine. Well, I don't know that there's much more that we can go do at this stage. Senator Wiggins, your hand is up. Up for a new intervention or from before?
Two things,
keep your powder dry. Hold on, Clark, Mr. Clark. Okay. The intention is that when Barvin does their presentation, we will have them in the committee room, and they will be streamed live into this room. With me? So as to facilitate the social distancing requirements and so on, just like what happened in estimates. I presume that the senators will be familiar with that. But effectively, the committee room is just across the room from where we are. So they will be seated over there. They will say what they have to say, and we can ask them, we can interface with them from over here.
Chair, just a concern in relation to the practicality of making the amendments necessary for Friday. If we're having the extra session on Wednesday, it does create some.
No, I understand that you will not have all the amendments ready. I understand that. We're just keeping a record of things suggested and so on. The committee still has a little bit of life left in it yet. Senator Wiggins, floor is yours.
Yes.
Please proceed.
Thank you very much. I was only saying that in terms of Barvin, I think that we probably would have to allocate a whole day for them, both Barvin and the Association of Wayside Vendors, because they are like one of the most important stakeholders in this entire exercise. And just to limit them to 2 hours essentially might not be enough. So I would think that on Wednesday, we could dedicate that time to both Association of Vendors. And secondly, on page 40, the same where the minister signed at the end of the vending license, it has the minister responsible for public markets and the minister responsible for fisheries. So I don't know if you want to say specifically the minister responsible for agriculture and then the minister responsible for fisheries and public markets, which could be one and the same. So we just want, so there will be a little bit of duplication there on page 40.
Well, it is actually, it is structured to reflect the current arrangements, but your point is taken. It may not always be this way. With respect to the vending association, I hear you and I agree with you, Senator. The fact of the matter is that my judgment was that we give them the first bite of the cherry. If it is felt by lunchtime on Wednesday that there is a desire for them to have further contribution, that can be accommodated. I'm just trying to manage the day as best as possible, because equally, you may find that there are so much in agreement with that which is put before the subcommittee that there are no challenges. It is for us to by way of our exploratory questioning, find out whether there are any adjustments or amendments to the legislation that are desirable. Are there any other requests for the floor? No? Honorable Leader, the opposition. Oh, the Honorable Leader, the opposition wants to make a motion to adjourn. That is seconded by Minister Humphrey. Thank you very much, ladies and gentlemen. We are adjourned 10 o'clock on Wednesday morning. Could we please be as prompt as possible, because that way we will be able to get through the business of the day. We will, if we need to do a deeper dive with Barvin, we will do so. Don't worry about that, but we may not do so on Wednesday. Precisely. They can come back. Same thing with the other association. Grateful to you all.